Hello everyone, I am Saloni Tyagi, Head of the Department Faculty of Law, Kalinga University. Today I am going to talk about Article 20 of the Indian Constitution, which is a part of our fundamental rights. Article 20 says that protection in respect of conviction for offences. It says that no person shall be convicted of any offence except for violation of law in force at the time of the commission of the offence of the act charged as an offence, not be subjected to a penalty greater than that which might have been inflicted under the law in force at that time of the commission of the offence. This article says that no person shall be prosecuted and punished for the same offence more than once. It says that no person accused of any offence shall be compelled to be a witness against himself. Next article is Article 21. Protection of life and personal liberty. This article says that no person shall be deprived of his life or personal liberty except according to procedure established by law. In this article, in 2005, one more right was added, which is right to education under Article 21A. Next is Article 22. Article 22 is protection against arrest and detention in certain cases. This article says that no person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Basically, this article says that anyone who is being arrested has the right to be informed that what offense he has committed and why he has been detained, and he has the right to get the legal aid by the legal practitioner of his choice. This article says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of arrest, excluding the time necessary for the journey from the place of arrest to court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. Apart from that, this article also provides few exceptions. Clause 3 of this article says that any person who for the time being is an enemy alien, that means any person who belongs to the country which comes under the enemies of our country, they can be detained, and the clause number 1 and 2 shall not be applied on that specific individual. To any person who is arrested for or detained under any law providing for any preventive detention, that means any person is being detained for providing preventive detention on that particular situation, these provisions are not going to be applied. Next, in clause 4, this article says that no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months. So, if any person is being detained for the process of or for the cause of preventive detention, that particular person can be detained, but not longer than 3 months, unless an advisory board consisting of persons who are or who have been or are qualified to be appointed as the judges of the High Court has reported before the expiration of the said period of 3 months that there, in its opinion, sufficient cause of such detention is lawful, or it can be extended beyond the maximum period. Such person is detained in accordance with the provision of any law made by the Parliament. When any person is detained in pursuance of an order made under any law providing by a preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. That means here we are talking about legal aid. Next clause of this article says that the authority making any such order act as in referred to that clause to disclose such facts which such authority considers to be against the public interest to disclose. Article 23. Prohibition of traffic in human beings and forced labor. This article says that traffic in human beings and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with the law. Nothing is in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such services the state shall not make any discrimination on ground of religion, race, caste or class or any of them. Article 24 talks about prohibition of employment of children in factories, etc. It says that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any hazardous employment. Article 25. It talks about freedom of conscience and free profession, practice and propagation of religion. This article says that subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. Article 26 talks about freedom to manage religious affairs. This article talks about public order, morality and health. Every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes. It says that any specific religion can manage its own affairs in matter of religion, to own and acquire movable and immovable property, and to administer such property in accordance with the law. Article 28 talks about freedom as to attendance at religious instruction or religious worship in certain education institution. No religious instruction shall be provided in any education institution which are maintained by state fund. This article says that any religious instruction cannot be provided to any educational institution which is run by the state or by the state funds. They cannot talk about any specific religion, or they cannot run their organization on the basis of a specific religion. Article 29. Protection of interest of minorities. This article says that any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. This article says that no citizen shall be denied admission into any educational institution which is maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language or any of them. Article 30 talks about right of minorities to establish and administer educational institution. This article says that all the minorities, whether based on religion or language, they shall have the right to establish and administer educational institutions of their choice. This article also says that in making any law providing for the compulsory acquisition of any property of any educational institution established and administered by the minority, the state shall ensure that the amount fixed or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. The state shall not, in granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether it is based on religion or language.